Hi, I'm Manny Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer, and today's video reaches into our legal hotline mailbag. Here's the question. My office received a backup offer with all the relevant addenda, including the backup addendum. On the backup addendum, the selling agent wrote, quote, "Seller shall not disclose to the first sale buyer that this backup agreement exists," end quote. Is that legal? Enforceable? Is the seller obligated to oblige? If you'd like to discuss this before I give you my answer, go ahead and hit the pause button. Okay, sufficient pause. The answer is yes, if the seller agrees. Certainly the seller is not obligated to agree that seller will keep secret the existence of the backup buyer from the first position buyer. But if seller is agreeable to that term and signs buyer's offer as drafted, then yes, seller has entered a backup agreement with the backup buyer in which seller agrees contractually that seller will not disclose to the first backup buyer the existence of that seller won't disclose to the first buyer the existence of the backup buyer. Is that a good idea for seller to do? Depends on the circumstances of the transaction and seller's motivations. There would certainly be some circumstances where seller would want to disclose to the first buyer that seller has a backup buyer as an effort to push that first buyer along the path toward closing and keep that first buyer focused on the goal of closing this transaction in a timely manner. Maybe dissuade the first buyer from coming up with some really horrific inspection requests, as an example. You can also probably think of situations where the seller wouldn't want the first position buyer to know about the backup buyer. Maybe the backup buyer has a better offer or would create a stronger agreement for the seller, and so the seller is actually hopeful that the first buyer goes away somehow so that the seller can move the first buyer into, the backup buyer into first position. And in that circumstance, maybe the seller wouldn't want to disclose to the first position buyer that there is a backup buyer. If that were the case, then seller would certainly be happy to enter into the backup buyer agreement with the backup buyer asking the seller to agree not to disclose the existence of the backup buyer to the first position buyer. So in order to analyze this question thoroughly on behalf of your seller, you're going to have to help your seller analyze the pros and cons of either disclosing or not disclosing to the first position buyer the existence of the backup buyer. And if seller comes out on the end saying, I like this backup buyer, I'd like to enter in a backup agreement with this buyer, and I don't want the first position buyer to know about this backup buyer, then by all means, seller should pull out their pen and ink the deal and move forward with this backup buyer. But if seller comes out on the other end of this analysis, it's saying, the existence of this backup buyer is more valuable to me as a tool to push the first position buyer than as simply a buyer in reserve, then maybe the seller would want to strike that provision on backup buyer's agreement and counter backup buyer's offer, understanding that when that provision is struck, it is in fact a counter offer back to the backup buyer, and the backup buyer may take the fact that that provision was struck as enough of an indication that seller is not motivated to sell to the backup buyer, and backup buyer should go find another property to purchase. That may be what happens, or it may be that the backup buyer says, I'll take whatever I can get, and enters the backup buyer agreement with the seller anyway. There is no right or wrong answer to this question, except that you as a listing broker have to understand the situation enough to be able to help your seller think through the pros and cons of either choice. If you need assistance in helping your seller think through this issue, grab your managing broker and ask them to help you analyze this situation either with you and your seller or before you meet with your seller. Because this is a more complicated issue than most brokers deal with on a day-to-day basis. And you have to think through the potential ramifications so that you can educate your seller as to those issues before you sit down with your seller. Hope this makes sense. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.